Hello, my name is Serrano Keith Baldio, and this is Texas Justice Review. This is a news show, not a political show. I mean, it is political, but it's the news. We don't give legal advice. People are asking me, what happens to the Kathy Stewart election fraud case? I'm going to try to give you a quick rundown because there's so much going on in my head and the investigation and laws. So here's where we are. This morning I received an email or some kind of document that the judge in the case is asking the case to be dismissed or held from her courtroom. Let's see, I'm going to open it. I'm going to start and just walk you back to what's going on. So this is the order from the judge. And it says, order of case closing. Interesting, because I thought we were still in trial. And it said, this case is stayed pursuant to Texas Civil Practice and Remedy 51.014, pending resolution of a matter subject to appeal or until further court order. It is therefore ordered, adjourned, and decreed that the clerk of the court shall close this file and remove it from the court active document of pending cases. Do you know how we got there? I'll tell you how we got there. So when I filed this case, Texas election law specifically tells the judges that you must expedite election cases. It is Texas Election Code 273.081. It says the court shall give precedence to any election-related proceedings over all other cases. The court must hear and decide election cases as quickly as possible. So I know Judge Purdy here, she's not into election law and probably she didn't do her homework, but you have to expedite election cases. But all I got was this case being dragged and, delays after delays after delays. So they're trying to run off the clock on me. They're trying to run out the clock. So here's the manipulation that took place. Judge Purdy has immunity. She has immunity for me suing her for damage that she's caused me by delaying the case, when the law specifically tells her she cannot delay the case. Judge Purdy's immunity also covers whoever she rules for. So if she rules for Kathy Stewart now has immunity. Can't sue her because she ruled, you can't sue her. And so when I filed the complaint, the complaint was that Kathy Stewart lied on her application for city council. She lied about a residency living in the district that is addressed on 2 occasions. She lied about being an attorney when State Bar says she's not. And also she cannot represent herself as an attorney to practice law. So I took this case, I filed it, it went to Judge Purdy. And she didn't expedite it. She saw it was an election case, and she refused to expedite it. That's a problem right there. Maybe she saw Kathy's case. Maybe when I served the other side, somebody calls somebody in the back room and say, hey, let's have a conversation about this. Kathy Stewart is a very powerful, influential person through her husband, powerful law firm who they're connected in City Hall with, a lot of pipelines in there, a lot of properties. So this is a lot of political power. And I was told that Judge Purdy is running for office in the appellate court. This is not going to look good. And I think the Republicans is going to have this case as a weapon to show, nope. So here's the legal wrangling that took place. On April 11th, I filed an emergency motion before the court to expedite this case because the election law says so. It also says that there's an election moratorium, and there's a rule. It's called Election Code 273.061 that a case must be filed 51 days before the election, and if there's an element of fraud and criminal violation, you can even file it 51 days after the 51 days. But then once that 51 days start, the law tells the judge that you must expedite the case. Because you can't sit on an election case that you gave the plaintiff 51 days to come to court with. And those 2 elements go hand in hand. It's an expedited case, and that's why we gave the plaintiff 50 days. But when I went there on 11, Kathy said that I don't have a case because even though she may allegedly commit fraud and lie to the public, which she did, that I do not have a remedy. The judge said she gave the judge 3 stones to put in front of anyone filing these complaints for criminal activity on an application for city council, that you must meet these 3 elements, which is a lie. Nothing in the election code says you have to meet 3 elements. It says if they committed fraud, you find out there's fraud, then you take action against them, and it tells you what action to take against them. One of them is removing them from the ballot. One of them is not validating their votes. And I'm going to quote you a few others in a minute. So the judge, I had an argument before the judge, and she said she agrees with Kathy that there is no remedy or relief for catching a person lying or committing fraud on a document. That's what Judge Purdy ruled, that anyone can take a document or lie about the address that they're living at, give a false amount of voters. Voters can fraudulently, if they find out that the voters committed fraud, and they can lie about their occupation and other places, that because there's no remedy to resolve the lawsuit, that the lawsuit has to be dismissed. This is what she ruled. So every criminal who fills out an application for a place on the ballot going forward can use my name, Kathy's name, as a defense. So this is the application. It is a sworn statement by a notary public. If you lie about your occupation, if you lie about the years you're living there, if you lie about your voting status, you can still proceed in the election as a felony, as a fraudulent person with fraudulent documents. And I tried to argue with this judge. I said, Your Honor, she committed fraud in the document. And the judge says, I've made my ruling. And then she said, if you want to go to the appellate court, because it was a big argument, and mainly the judge was hostile towards me. I don't know if it was because she was trying to defend Kathy. She's a Democrat, but a rhino Republican, because allegedly they said she goes to the Republicans and pretend she was one of them so she can get the money and she can get the votes and she can keep the seats, but then she go back and support the Democratic views, which Kathy Stewart once said she will support a sexually explicit business license for trans kids. She's supported by the Lake Highlands Blue Democrats. So a lot of things are coming out. She's not really a Republican. So anyway, after the hearing on April 11th that I had to force, the judge ruled that my case was dismissed. It was dismissed because I didn't have jurisdiction. I didn't have jurisdiction because I didn't have injunctionary relief. There is no relief that can be given for finding Kathy guilty of fraud. That was the ruling. I cannot have any remedy or relief, injunctionary relief, if I find Kathy guilty of fraud and lying on a document in Judge Purdy's courtroom. You want to tell me if this is law or not, so we're going to continue. Here's the ruling. It's called injunctionary relief, right? And she denied my injunctionary relief that we found her guilty, she's a fraud, but she's still getting voted into office. So the judge gave her immunity to continue in the election. The judge then filed another order. So anyway, when that was done, the Dallas Morning News, the 3 attorneys that Kathy had, continued, and then we all thought it was over. And then the judge, after I filed, and she said, go ahead and file appeal, the judge. If you don't like my decision, go ahead and file an appeal. The decision was based on the injunctionary relief and the complaint because I couldn't I could prove it because the law says I can get it. The law says I can have her removed. The law says I can have her not be certified. The law said I can object to her being sworn into office. All these reliefs are available in the law, right? I thought I explained it to the judge, but she's saying, well, I'm going to deny all those reliefs. Why? Because I'm the judge and I'm making up a new law right now that if somebody commits fraud, they cannot be sued because there's no relief to sue them, to get by suing them. Yeah, that's the exact ruling. So after I filed my appeal, here's my appeal on this day. a lot of things happened. A lot of records was moving places, and then the judge's clerk, Alonzo, who was very nasty to me when I called, not respectful, and she calls me up rude and says, "Did you file an appeal?" And I said, "Yes." "And why did you give us notice?" And I didn't know you're not supposed to give the judge notice. It goes to the appeals court, but I did. So once she found out that I did an appeal, she went ahead and she did a denial of Kathy saying I don't have jurisdiction to bring a case in the courtroom. Well, wait a second. It was already ruled under the injunctory relief that I have no relief. And since I have no relief, I have no case. That's what Judge Purdy ruled. You can't show me what kind of relief I can give you, or I don't know any relief I can give you, because she failed to check the law. The election law that says, yes, if the person lie on their application, you can do this, you can do that, you can invalidate them. She didn't check that. Or maybe she just, something is happening here that's just suspect. So after she ruled that I can't give you relief, I'm dismissing your case, she went back and says, I am now taking the case, that her own handwriting, that the court has jurisdiction to hear the case. And this was filed after I did my appeal. So now I appealed this injunctory relief in denial, right? Then she filed, hey, I got the case now, I can take it actually. And then I was like, okay, so what do I do with this? So I wrote to the appellate court and I said, this is blatantly to obstruct the case in the appellate court, because she already ruled that I don't have injunctory relief. She already ruled that no application to challenge fraud in an election is allowed in civil court because there's no relief. This is what her ruling is. There's no relief. In other words, somebody can commit a crime and you say, well, you know, we can find the money and or we're just going to let them go with the money, you know? It's just not a law that makes sense. I mean, the ruling that makes sense. Why would you say I have no case because I have no remedy, and then come back and say, hey, I have the case, I'm taking it to trial? So even if you take it to trial, you already said I have no remedy. So it doesn't make sense. So I think she did that to put a monkey wrench and further delay the case. And then this morning I get this thing, she's asking the case to be closed pending what the appellate court, because I wrote to the appellate court and I says, I need you to clarify what the judge wrote this morning. Because she already said that I don't have a case because I don't have injunctory relief. But now she's saying she wants to hear the case. So can you tell me, because now she filed it with you, what do I do? So now, but then since she said she had the case, I filed a motion for a temporary restraining order. The temporary restraining order is to stop, now that she's saying she's going to try the case, okay, because if you try the case, now I'm back on the, you know, the campaign trail with, hey, you're going to try the case. I'm going to have the opportunity now to hold her in contempt, to stop her from swearing in should she win. So let's bring the case back to you. Let's do an injunctory relief. So I go to her and she says, well, since you wrote to the appellate court and told them you wanted them to review the case, I am not going to hear your case. I'm not going to listen to what you have to say. I'm just going to hear what they have to say first. So that confuses everything now. And then last night I wrote to the appellate court and I told them, look, I want you to keep the injunction relief case to investigate it, because it's going to cause some major problems when people lie on the application. But since the judge says she has jurisdiction to the case, now has jurisdiction to the case, and she can actually hear this case, I would like you to send that back to her to see what can she hear. But the part of the injunctory relief, I'd like you to keep, because on May 11th, she ruled on that. Now, on May 15th, she came back and she said she's going to hear the case. So we have two conflicting things by this judge. First, you don't have a case because you don't have relief, which you can get, which is not true. And then go and sue me if you don't like that decision. And she said so in the transcript. I was, go and sue me if you don't like what I said. That's what she said in the end of that meeting on April 11th. And now she's saying, hey, on April 15th, after I did a notice of appeal for the 11th, yeah, you know, I have jurisdiction. I'm going to hear the case. Make your mind up. Make your mind up. And I think this is being deliberately done to sabotage my case to aid Kathy Stewart. And this is what you call oh, I'm not going to say that word, but I have a term for these people who, like gangsters in the judiciary and the political system. So that's where we are. So today's the 22nd, early voting starting on the 21st, the day before early voting. And she put this in the record. So now I got to wait for the appellate court to decide what are we going to do with this case? Because she knows what she's doing. She knows this woman is highly experienced in obstruction and knowing what to do and what to say, because I've listened to some of her videos. Gotta do this person is this, and that person is that, the jury is this. Also yesterday, when I did the temporary order of protection, Kathy Stewart is now in default. She's in default for not answering the case on time. And there's a civil code that says if you're in default, this clock can rewind the time. So and if you look at the case, I'm going to show you, if I didn't show you how to go find this case, go look at all the documents and you'll see for yourself what they're doing. But what I want you to look for is on the 21st of April, I filed a notice that the case was in default. The judge has not entered it into the system. Her clerks have not entered it into the system that I have a motion for a default judgment against Kathy, which means the case could have been over yesterday. But the judge decided, well, since you filed this on the appellate court, I'm going to punish you. I'm not going to hear your case. I'm going to wait for them to make a decision. But then why did you? It's just, she's confusing everything. But she's doing it intentionally. And I hope the Republicans are watching, because she wants to be on the appellate court. I'm going to show you how to find this case so you can see for yourself. Go to Google or whatever you use, and you're going to search Dallas County court records. And then you're going to open up online records search Dallas County, and then you're going to see this page with the officials on it. And then in the middle, you're going to see Dallas County District Court Case Information right there. There's a blue line. It says Dallas County District Court Case Information and Documents. Click on that. It opens up a portal. You go down, you see 3 bars. The one to the left, when you look at the screen, search, smart search. You click on that, and you're going to see a place for the case number. This case number is DC, as in District Court, 25, as in the year, dash, DC, dash, 25, dash, 03. Eight, 4, 1. I think. Let's find out. Click on I'm Not a Robot. And there's a case. You click out under the case number, you'll see the case. You click on it, it's going to open up the case. When you go to the bottom of this case, I want you to take a look. You will not see the motion for default judgment. They refuse to enter it, but yet they're entering all kind of stuff. When I filed a default judgment, I sent it to the other side. They immediately filed a proposed order denying plaintiff's motion for temporary relief, because I told her, take a look at the relief again. Defendant amended plea to jurisdiction. She already ruled on that. She has jurisdiction on a temporary order, because my temporary order was that now that you have jurisdiction, Judge, you told the appellate court that now we're going to stop her from being certified. So they amended it, saying it's supposed to be a reconsideration, but they just put in a proposed order. And then you have the appellate court, and then you have the order from the judge closing the case. But you do not have my order that I filed and time-stamped at the clerk's office saying the case is in a default judgment. They did not put that on the record for anyone to see. So the default judgment would have ended this case yesterday, but they're playing games. So now she's closing the case that the appellate court, since you went to the appellate court against me, I'm going to teach you a lesson and what politics and law is, and politics come before law. I'm going to let you know how smart I am. I am going to put a monkey wrench in your case. I'm going to further delay it, and it's going to go to after the election. And even if you find her guilty, since she's already sworn in, the only thing that could happen is that the authorities can have her arrested. And then after the arrest, she can be removed, and you won't still be seated, because now you got to do a new election. That's what's happening in the case so far. There we go. This is the motion for default judgment that was filed against Kathy yesterday, right? And you'll see 7 documents by the defendant and the judge and the circuit court, and the appeals court was entered also, but you will not find this default judgment that was filed in the morning at 11:55. At 11 o'clock, you see all those other things being filed. So why are they withholding this from you, the public? And that's where we are. So now I have to find out, how do I go back to the appellate court and say, you know, do I want a motion for a new trial? Do I want to recuse her? Do I want to get it to a motion for reconsideration? And because I did ask the appellate court to hold the jurisdiction that I have nothing, that she said, if I win, and then send back the part where she said, hey, I now have jurisdiction. This is 5 days later, I have jurisdiction, by the way. Hey, after I file an appeal. So what did I file the appeal on? I thought that was your final judgment. Now she said, no, I got him. I'm going to show him. That was not my final judgment. I actually still have jurisdiction over the case. Here's the kicker. If you now claiming jurisdiction over the case, why didn't you say so on the 11th? On the 11th, when you dismissed the case, why didn't you say we're moving forward with the trial? Why didn't you say on the 11th to the attorneys, prepare yourself for discovery? Why didn't you say to the media and the public, we are only dismissing to jurisdiction because he has no remedy, but we're moving forward with the case? Because there's a conflict there. You can't tell somebody, I'm not giving you remedy. I am not removing her from office. I am not disqualifying her votes. So which means even if you win, you get nothing. And that was the mentality on April 11th. So if you said that, and then you said, if you don't like my ruling, go and sue in the appellate court, which I did, why did you run to the appellate court now and say, hey, guess what? I do have jurisdiction over this case. I'm taking it back. But even so that you have jurisdiction, you already said you're not going to give the plaintiff any remedy. Even if you found that the person lied, committed fraud on their application, which she did, she's free to go. She's free to go into the election as an unqualified, invalid, fraudulent document, and nobody can tell her anything. So she used her immunity to give her immunity. Before the appellate court is this case. And by coming back to the appellate court after I did my appeal, I'm now saying, hey, by the way, I want jurisdiction back. But even so, the appellate court has to ask, if you want jurisdiction back, why did you already tell the plaintiff that you won't get remedy? What would be the purpose of getting the case back? And I think that's what she wants me to do. That's what Judge Purdy wants me to do. She wants me to continue on that time, asking the appellate court questions after questions after questions, so she can run out the clock on this case to help her. Miss Powerful, Miss Wealthy, her husband connected all over the place. And that's politics. That's the corruption that's in politics. This is a simple case. Kathy Stewart lied on her application. She lied in 2023. She lied in 2025. And she will continue to lie. And it's not just her. Many people can now lie on these documents, even on the sworn statements. And then when you go to court, based on the ruling by Judge Purdy, they can say, hey, in Ballius versus Stewart, Judge Purdy ruled that even if you find them lying, there's no remedy. There's no injunctionary relief. You can't challenge their votes. You can't challenge them swearing in. You can't challenge their eligibility because too close to the election, because whatever the judge decided, that was not going to happen. So that's what's happened in this case. And I'm sitting here trying to figure out, the law is very simple. The judge is supposed to stop the nonsense about eligibility and say, yes, there is. She does have relief. Relief is if she's caught lying, she cannot be certified. Her votes cannot be certified. She cannot be sworn into office because the document was fraudulent and the office is being ill-gained. The office is being fraudulently gained. And if the judge knows that the office is fraudulently being gained or the document was fraudulent, as with any bank proceedings, any other contracts with anybody else, an application, if it is false, it has to be voided. it has to be, she has to be ineligible. And the judge is saying, well, I'm not going to give that to you. I'm not going to give to you and make her ineligible, even if you find her fraudulent. Not going to do it. And that's a case law now. If I don't overturn this, this is the case law. So if you're an elected official, even in the appellate court, and you're listening to this, Baldio versus Stewart, if you have an opponent and they lie on a document and they come to court, they're going to use Baldio versus Stewart that says you can challenge the document. You can't challenge the document. You can't challenge the fraud in civil court because there's no remedy. Just as Kathy used Carolyn Arnold's case to say, hey, it was too close to the election and she wanted the names removed from the ballot or not removed. And they used that. Kathy used that big time with her lawyers. And I was trying to tell this judge, that's apples and oranges. I'm simply asking to look at this application. Carolyn Arnold actually wanted you to stop the election and stop the vote and all that kind of stuff. I'm not asking for that. I made it very clear I did not want to stop the election. So that's apples. This is oranges. But the judge listened to it and put the apple in the orange basket and gave it to Kathy. And so now I want new appellate court judges and elected officials in any capacity, at any level, even Congress, that there's a law that says you cannot challenge somebody lying on an application because according to this ruling, there is no remedy to remove them from office or block them from office or block them from being eligible. That is, folks, a new law given by Monica Purdy of the 95th Court, who wants to be in the appellate court, and just told me, as a minority, I'm going to bar you from getting elected in District 10, because what she did is once she validated this application by dismissing my case, voters are now going to say, hey, that case was thrown out. You know, they don't have a case anymore, and Kathy is free to run for office. And this judge sends a false and misleading, talk about element, to the public, that Kathy Stewart can still be on the ballot if she lied on the application. And you can still vote for her. She committed fraud, you can still vote for her. That's what Judge Purdy of the 95th District Court ruled. Instead of saying, if I find this application to be fraudulent, I am going to void this application and make it ineligible. She doesn't have to make it ineligible. She has to void the application. My job is to go after she wins, or if she wins, and say to the city and the county election department, I am invalidating her votes. That's my job. The judge ruled that the application was fraudulent. That's all I wanted. And it is fraudulent, and if Ms. Babalia want to go and challenge it, he can do it on his own. That was supposed to be the ruling. That was already supposed to happen on April 11th, when she looked at this and says, well, you're supposed to be in this residency continually for whatever time you said there, and you can't be 2 years. Did you live at that residence for 2 years in District 10? And the answer, for 41 years, as you put on the application. No, then you lied. So I can't let this application go through. I am voiding this application, and Mr. Baldio is instructed to take whatever action he can take on his own. But what she did is she put herself in the middle of the election and says, I will be the boss of the election. I will now void every law. I will void every election code. I will void election code 273.081 to expedite, because I am not expediting. I void that, even though Mr. Baldio filed it before the 51 days, because it says the 50 days. You see the 50 days right there in the middle? 50 days I filed it before that. And the legislator said, if he files it 50 days, you got to expedite it. That 50 days means you've got to expedite it, and that's the ruling on the top. And she decided, I don't care. This is supposed to be my due process. That is the due process I had that she also violated. Didn't care about my due process, because the law is the law. You have to give him that. She doesn't want to. And now she's doing all these things to delay. Instead of expediting it, she's now delaying it. All delays on anything she could. And that's why this morning, when she wants to teach me a lesson, okay, you want to listen in the law, Mr. Baldio? I'm going to show you what I can do. I'm going to dismiss your case, just to teach you a lesson. And when the appellate court tells me if I want to reopen it, that's fine. I'll do that. But until now, your case is dismissed. I have jurisdiction. I have jurisdiction in this case. I have injunctory relief. And here is the injunctory relief that I have if I brought it from my office, because I'm in my studio. The injunctory relief. All right, I'm just going to say on the top of my head. Injunctory relief is you can have the person votes not be validated or counted. You can have them not being sworn into office. You can have the city clerk. There's a term. There's a legal term. Instead of not certify her votes, not have her votes be counted, not have her sworn into office based on the fraud against the community. And there's two other elements that you can use not to block fraudulent, lying candidates, but to make sure that they do not get back on the ballot. And if they get back on the ballot, to make sure they do not get back on the city council. This judge was responsible for making sure that the law was followed. The case was expedited. No matter what, you expedite this case. She violated the expediting of the case. And this morning, she didn't have to close the case to say, I'm waiting for the appellate court. She just had to wait for the appellate court. We just wait for them. They're going to make their decision on whether or not this case can come back to you. Because I didn't, it was a letter that I filed with the appellate court, not a motion. There was no motion. There was just a letter saying, hey, this judge now is saying she has jurisdiction. Can you tell me whether or not you have jurisdiction or she has jurisdiction? That was my ask at the appellate court, because now she's saying she does. So she's using that to say, I'm closing your case. Smart. To delay it further. When the law says you cannot delay this case. It's her job to, and if you don't want the case, take it and give it to somebody else. But I'm just saying to the Republican Party or Democratic opponent, if she's going to have a primary, use this. Show what she's done with this case. This is a political case, and she's messed it up. I'm not going to say if it's willfully, intentionally. I'll leave it for you guys to understand. Is she messing it up intentionally? Just to help Kathy and give her immunity. Just remember, this case, she has immunity. She gives her immunity when she rules for her. And if you challenge her, the judge has immunity. The judge gave me immunity. Can't sue me again because the judge says you can't. So that's where we are. Fighting for justice is not easy if you're pro se, but you know what? It's worth the fight. It's worth the fight even if it's just to expose this kind of stuff. And it's worth the fight even if it's to call off the authority that can come down and says, well, Kathy may have gotten away civilly, but she's not going to get away criminally. And I'm going to leave it there. Thanks to Judge Purdy and Purdy's law, we now have an established law that says no one can challenge lying on a ballot to become city council or an appellate seat or a congressional seat or any seat. And they're going to use this hard because they used the Carolyn Arnold Councilwoman's case hard. Didn't even apply, but they won with it. So they're going to use this card on any challenge to a ballot. And you know what? It's all Democrats here mostly, so let them go after her and says, you needed to turn over this. Because if we have people coming in here and they do this and we catch them lying, by your law, Purdy's law, we can't challenge them because you said there's no remedy. So we can't bring a case because there's no injunctive relief, which is remedy, and now we're caught here. So good luck to all of you who are rerunning for election. Hopefully you don't have some carpetbaggers coming in here and fill out applications and not even having enough votes, but after they get on the application and you said, well, they lied on these votes, too bad. They fill out, they don't even live here, too bad. There's no relief for that. They're not even a lawyer. They're not even this person that they said they applied for. They're not even they lied about their occupation. Too bad. They voted. They just started voting. They didn't even vote in the district. Too bad. But the law says they have to be here for a whole year. They've just been here 9 months, and they put that on the application. They lied. Too bad. The law said they have to be in my district for 6 months before they even go on a ballot. They just got here like 2 months ago, and then they got approved to be on the ballot. Too bad. That's what Kathy's and Judge Purdy's new law says. Hey, folks, you can come in and run for office even if you're 2 months in the district. You can move into any district within 2-3 months, right? Once you get this passed, and the clerk, they don't check. They don't have the authority to check, or the investigators. They don't check. If you said you've been 2 months, if you said you've been there 2 years and it's actually 2 months, too bad. Too bad. There's no remedy. According to Judge Purdy, there's no remedy for lying on an application to be a council person. So chalk that up to revoting for Judge Purdy. And then the politics she put on me, putting in monkey wrench at the appellate court when you already ruled there was no remedy. And you told me to go sue the appellate. She's the one that says, if you don't like my ruling, go sue in the appellate court. And I did. You're the one that says go sue. And after I sued, I didn't think she think I was going to appeal her. I don't think she thinks so. She thought so. And now that I appealed her, she's like, oops, I guess other judges are now going to review my case. But Miss Purdy, if you're reading this, you might, if people are saying she needs to recuse herself, others are saying no, you want to get that case right before her, because I can't tell you the reason why. But I just wanted to show you part of the, I'm going to close with this. This is the transcript, because Serrano is not stupid, Judge Purdy, and demeaning me in your courtroom and insulting me is not going to help. So let's find out. This is the end of the transcript at the last hearing on April 11th, when we all thought the case was dismissed. This is what's happening in that courtroom, and now you know. I said, you have not met your burden with regards to the injunctory relief you are seeking. And that is the key to this. That is what she's saying. Even if you find Kathy guilty, what remedy is there available to you? What's your injunctory relief you are seeking? And she's saying, if you think, I'm going to read what she says. So that's one part. With regards to the injunction relief. So that's when she put the monkey wrench on the 15th and said she now has jurisdiction to hear the case in the appellate court. It's just obstructed the whole dream of things. Let them rule on that. And we're going to get to the part where it should have said, let them rule on that. And the issue is moot. This is going to be the ruling of this court. I will sign the order to that effect. She will sign the order to the effect that I can't prove that there's any remedy available to me. And I'm telling you what she says as far as Kathy is concerned. Here's what she says. Let me say this with respect to plaintiff's request to this court for any type of injunctory relief. Remember that. Any type of removing Kathy, making her ineligible, that her votes are fraudulent because the application is fraudulent, telling the city she cannot hold office because she lied on the very document that you gave her to sign in a sworn statement. That was fraud under civil law and criminal law. You cannot allow her to be seated because she lied to you on that document. So any kind of things like that, the judge is saying, here what she said, let me say with respect to plaintiff's request to this court for any type of injunction relief to remove or not count the votes as it relate to Kathy Stewart in the, and then I try to speak, Your Honor, before you rule, can I make, because I was going to suggest something, an alternative, and give her different things. She cut me off, didn't want to hear any other remedies that I might have. And then she continues to say, before the municipal election, the court is going to deny your request. So let's just say I find her guilty. And I said, okay, here's all the things that the law says I'm available to. Making her ineligible, telling the city her votes cannot be counted because she lied and she frauded the voters who voted for her. If you lie in a document to defraud the voters, should the voters be counted? Stop her from being sworn in. There's a lot of things that's there. You can Google it or what you do to find out yourself. Don't take my word for it. This is the law. So, in essence, Judge Purdy voided the entire civil code of procedures when it came to election laws. in Dallas County or in Texas as a whole. And then she says, you've not met your burden with regards to injunctive relief that you're seeking. I'm seeking to have her invalidated. I'm seeking to have her not be sworn in. I'm seeking to have her votes, yes, not be counted because she lied and deceived the public to get it. And if you let this case go before the public too, Judge, you're helping her lie. You're being an accessory to that. I didn't say that to her, but I'm just saying it now. Accessory to her lies. This judge is accessorizing the lies of Kathy Stewart. I know you're going to be watching this video because somebody's going to show it to you, but if I come back in your courtroom, it's going to be more of what you did to me and more of reporting it. This is going to be the ruling of the court. Was signed an order to that effect. I have a copy of the order that I already downloaded, so she preconceived all of this, right? She preconceived she was going to aid Kathy and help her. And I said, Your Honor, the application is faulted. Then she goes, I've ruled. Again, you and I are not communicating well, of course, because you're trying to lie and I'm trying to tell the truth, right? The court is of the opinion you have not met your burden here today by saying even if she's guilty, she's free to go. You, the public, you tell me your own common sense. She's guilty of lying on an application, committing a felony, and she's free to go into the election. That's basically what she just said to me. And then I said that the election is already in process. That's what she said. And I entrust that is in my complaint, which is, I said, I don't care if the election is in process. This is not to stop the election. This is to just invalidate her lies. I'll take care of the rest in the other court. And then she said, okay, I'm not accustomed to trying to persuade you about my ruling. Who talks to somebody like that? I think she thought I was pro se so she can be disrespectful. But I'm a publisher. Let's keep that in mind. She's got power, I got power. And if you disagree, so here's the part. If you disagree, you may go to the Court of Appeals. I didn't say that. She said this. They can review my decision here, and if they can either affirm my decision or they can reverse my decision. And then I said, I will file it tomorrow, Your Honor. And that was April 12th. So if you want to know, that's what's been happening in the court. That's what we're trying to change from happening. We're trying to reverse her decision because if you're an appellate court judge, be worried because this is going to affect you too. This is not indicative to just city council. This was a document challenge. And this judge says, doesn't matter. I am denying any document challenge in my courtroom because according to me and my own non-investigative, what I did because she should have researched it, or my knowledge, this was an opinion case. This was not a lawful case. There is no remedy. So I don't know why she called the case back. I think it was just to delay it more. And now you can see how she is dismissing it and holding it. I think she's further delaying it to help Kathy Stewart, the Rhino Republican who's being endorsed by the Democrats in Lake Highlands. Anyway, that's what's going on. This is Serrano Keith Bellevue. The fight continues. Kathy's going to, if she is elected, I'll self-fight it. And for the 2 years she's sitting there, if this judge says, yes, I'm endorsing her sitting there as a criminal for 2 years. And I don't know, I just don't like pro se people. I don't know, whatever her reason is. I will keep this case in the air lit for the next 2 years on both of these individuals. This is Serrano. Thanks for watching. Bye for now.
Help inside. Corruption's running wild. It's a lonely fight. Shaking things up in this Dallas town. We just don't care. They just don't frown. You can't win the game. It's a twisted race. Justice review is on the case.